Sir, welcome. May I ask you to please state your name and spell it for the
Yes.
transcript?
Ladies and gentlemen, my name is Lorenzo Galanti. I'm first counselor at the Embassy of Italy. I'm head of the Office for Economic and Scientific Affairs. And it's not without a certain degree of personal satisfaction that I testify here today before this panel in the light of recent developments in Italy on IP protection, both on regulation and enforcement. The government of Italy welcomes today's public hearing as an opportunity to reaffirm its commitment to a constant and fruitful dialogue on intellectual property with the government of the United States. In this respect, let me first mention the visit paid to Italy on May 24th last year by Assistant U.S. Trade Representative for Intellectual Property and Innovation, Mr. Stanford McCoy, to attend a workshop organized by the Italian Communications Regulatory Authority, during which he met with the Vice Minister of Economic Development, Mr. Carlo Calenda, and the then Deputy Director General for Global Affairs in the Italian Ministry of Foreign Affairs, Claudio Spinelli. The event was an opportunity to exchange views on the main intellectual property topics of mutual interest, including Italy's position in the watch list in the framework of USTR Special 301 report. I also wish to recall the visit of Italy's Vice Minister of Foreign Affairs, Master Dassou, to Washington on April 10th last year, and her meeting with the Deputy U.S. Trade Representative, Ambassador Marian Spira, an opportunity again to discuss the expected approval on the anti-piracy regulation in Italy. This regulation was eventually adopted. On December 12, 2013, the Italian Communications Regulatory Authority, also known by its acronym AGCOM, approved the regulations on the protection of copyright on electronic communication networks. It will enter into force on March 31st this year. With this crucial progress, Italy becomes one of the most active countries in the global fight against multimedia piracy, while ensuring adequate procedural guarantees at the same time. The submission on IPR issues provided by the Italian government for the Special 301 review includes a detailed description of the 5 chapters composing the new regulation. So today, I would just like to underscore that the aim of the regulation is twofold. On one hand, it promotes the legal supply of digital works, as well as encouraging and supporting users' education in this respect. On the other hand, it regulates the procedures applicable to cases of violations of copyright and related rights. And indeed, part of the regulation focuses on educational activities for the benefit of users, encourages the legal fruition of online contents, fosters the development of innovative and competitive commercial offers, and establishes a multi-stakeholder committee for the development and the protection of the legal offer of digital works. Its members represent consumers, authors, artists, producers, audiovisual media service providers, and internet service providers, as well as Italian institutions in charge of copyright protection in its various declinations. Before continuing on with my presentation on the procedural part of the regulation, I would like to underline an essential element, that is, notice and take down self-regulation procedures already adopted by the main websites operating in Italy, such as YouTube, remain valid. As mentioned earlier, the regulation also provides for enforcement procedures for online copyright violation and copyright violations concerning audiovisual and media or radio services. The relevant proceedings are initiated by the right holders. Subsequently, all interested parties, such as ISPs, uploaders, page or site owners, are invited to participate and present relevant documentation. Where an infringement of the copyright law in the online environment is certain, the Italian Communications Regulatory Authority is entitled to adopt different measures depending on the location of the server hosting the content. In other words, if the server is located in Italy, the regulatory authority may order the host provider to remove the digital work from the website, whereas if the server is located outside Italy, it may order access providers in Italy to disable the access to the website disseminating illegal content. It should be noted that the selective removal of the illegal content in the second case is not feasible because it would imply deep packet inspections, which would be against EU law. With specific regard to audiovisual media service providers, on-demand providers may be ordered to remove illegal content from their catalogs, and linear service providers may be ordered to refrain from retransmitting illegal works in their future schedules. In cases of non-compliance with the orders, the Italian Regulatory Authority is entitled to impose a fine from Euro 10,000 up to Euro 250,000. pursuant to Article 1st of the law number 249 of 1997. Procedures are in internet time, a maximum of 35 days and a special 12 days fast track for serious cases of piracy. Obviously, the procedures introduced by the regulation will coexist with the judicial protection of copyright. However, should the applicant approach the judiciary during the course of a proceeding before the regulatory authority for the same case, and should the case involve the same parties, the regulatory authority will dismiss the case and transmit the documents to the competent court. On the contrary, the administrative proceedings before the regulatory authority will continue regularly if the judiciary is approached by another subject. Finally, it should be noted that peer-to-peer programs aimed at the direct file sharing activity and end users remain outside the scope of the regulations, but are covered by civil and criminal laws. On enforcement, let me briefly refer to activities carried out by Italy's fiscal police, Guardia di Finanza, last year. Our fiscal police increased its focus on online copyright enforcement in 2013 and succeeded in closing 84 platforms of online marketing, distributing and broadcasting of copyright-protected content. This data reveals that those pertaining to the previous year have doubled. Concerning software programs, illegal copies for profit purposes, Italy's Supreme Court has repeatedly affirmed that companies copying a software program to use in their computers commit a crime. Therefore, a person who illegally copies or stores for commercial or entrepreneurial purposes programs for computers to make a profit commits a crime, as provided for in Article 171 of Law April 22nd, 1941, number 633. As far as counterfeiting is concerned, the Supreme Court Criminal Chamber affirmed the principle that the concept of illegal copy includes not only the unauthorized creation of perfect copies of a software program, but also the creation of software programs deriving from the development or changes in the original product, when the copy concerns a part of the program which is functionally autonomous and constitutes the core of protected work. Let me also inform you that the Italian Ministry of Foreign Affairs hosted a one-day workshop titled Intellectual Property, a Strategic Factor for Economic Development in the Global Market on January 27, 2014. High-profile event, and the topicality of the IP issues addressed provide evidence of Italy's increasing commitment to intellectual property rights protection. About 200 policymakers, representatives of national and local institutions, members of the academic community, associations, businesses, and media, as well as foreign diplomats participated, providing an opportunity to increase awareness on the economic aspects of intellectual property rights from an international perspective. In particular, the key role of creativity and innovation for companies operating in a globalized market in the era of knowledge economy was highlighted during the meeting.
Just so that we're at the 8-minute mark.
Okay.
You're welcome to continue. We have one question for you, so please continue.
All right. So I'll cut short on this event, which was indeed an important awareness-raising event. The Minister of Foreign Affairs participated, as well as the Minister for Economic Development, who offered his concluding remarks. Finally, let me conclude by adding that Italy expects that its position be thoroughly assessed in the light of the detailed submission from the Italian government provided within the 2014 Special 301 annual review process, as well as the additional pieces of information provided during this public hearing. Based on all that, it is our assessment that Italy should be removed from the watch list as an outcome of the current review. We look forward to continuing this dialogue with the U.S. authorities and all stakeholders in the future. Thank you.
Thank you very much. Do we have a copy of your
Yes.
submission? So
there are copies outside of it. I have one more, and I can.
okay, I apologize that the format here doesn't allow for full discussion of all of the issues. One, congratulations on the adoption of the long-awaited AGCOM regulations, and thank you for your detailed description of those. We'll certainly read your testimony as well as everything else that Italy has submitted, and perhaps even follow up with a meeting during the course of the deliberations. We had one question, which I will just ask very briefly. We're interested in knowing the regulations take effect March 31st.
Correct.
How soon after do you anticipate receiving complaints and being able to act on complaints under the new regulatory procedures?
I guess pretty soon. not immediately, because there have been several public consultations about this regulation. So the public and the stakeholders are aware of the content of the new regulation, and I guess they're prepared to make the best use of it.
Okay, that's excellent news. And one last question. So you have reached out to stakeholders. We've had situations elsewhere where new regulations are set up, but the right holders aren't familiar with the regulations and don't use them properly. And so a dialogue between those who want to use the regulations and those who are administering them is very important. Do you have plans for that?
Well, the regulation itself has been crafted in collaboration with stakeholders, in fact. And like I said, the public consultation has taken place extensively, so the regulation has been discussed with stakeholders. Of course, it will be, at its entry into force, I assume that there will be even more publicity, so that all the right holders, who are those who will activate the procedure, will be aware that they have this new tool to make sure that their right is protected.
Thank you very much. Thank you for joining us today,
Thank you.
and we'll certainly follow up during the course of the review.
Looking
Thank
forward
you.
to it. Thank you.
Next, I'd like to invite the government of Paraguay. Welcome. Thank you for joining us today. Thank you for making the trip from your capital. Please introduce yourself and spell your name for the transcriber.
Good morning, this is Susan Wilson. Good morning, member of the committee. My name is Octavio Ferreira. I am Director of Multilateral Economic Organization of the Ministry of Foreign Affairs of Paraguay.
Morning, everyone. Good morning, everyone. My name is Kuni Hashimoto. I'm from the Embassy of Paraguay.
Just spell your last name.
K-U-N-I. The last name is H-A-S-H-I-M-O-T.
Thank you.
In the past 12 months, the Republic of Paraguay has followed a path of significant progress in the defense and promotion of intellectual property rights. Last year, Paraguay participated for the first time in these important public hearings with representatives from our embassy. Now, for the first time, we are present with an official coming from our capital. This, along with the action that I will summarize in a moment, are clear demonstration that the government of Paraguay is committed to step forward in the protection of intellectual property rights and strengthen its bilateral relations with the government of the United States. Despite this improvement, we recognize that much remains to be done. At the same time, we recognize that the resources we have for this important challenge are very limited. And in this regard, the cooperation in all sorts of forms of foreign governments and international specialized agencies will be essential to achieve the objective set. In order to comply with the schedule, I will present a brief summary of the main actions taking place in my country. In 2013, the Law 4798/2012 that creates the National Intellectual Property Directorate, the INAPI, was regulated by Presidential Decree number 460. This regulation creates the organizational structure and gives the INAPI financial independence by assigning its own budget from January 2014. In November 2013, the INAPI launched a project that will help develop the National Strategic Plan on Intellectual Property with the support of WIPO. This will improve the national policy in all the areas regarding the protection and promotion of intellectual property. Also, in its first few months of existence, INAPI has signed agreements with institutions that facilitate its role in the protection of intellectual property, and now is working with other institutions to create a network to research and of research and development in the field of intellectual property. DINAPI is also working on a project for the legalization of software in both public and private sectors. This office has also improved its administrative procedures and registered for the first time in 10 years a pharmaceutical patent. They awarded in 2013 more than 70,000 titles of grants, of which nearly 7,000 were awarded only in the last quarter. That demonstrates that the efficiency has been growing. The General Directorate of Enforcement has conducted in the last quarter of 2013 100% of the verification procedures of allegedly infringing goods. Between September and December, 24 verification procedures and seizures of counterfeited goods were made. The procedures were performed in public and private ports and airports in Ciudad del Este and Asunción, and in the ports of San Antonio, Lambaré, and Puerto Falcón. Each time that allegedly counterfeited products were found, the complaint was addressed to the prosecutor and the products were sent to fiscal warehouses. DINAPI, along with the National Directorate of Customs, has conducted verification of a cargo plane from China in the Guarani Airport, close to Ciudad del Este, and that verification was the first joint presentation of the Attorney General, the National Directorate of Customs, and DINAPI. The procedures was covered by Article 37 of the Criminal Procedure Code, which establishes the jurisdiction of the courts of the capital, Asunción, for offenses produced abroad that take effect in the territory of Paraguay, declaring competent court specializing in intellectual property and referring the case to that court. And all goods seized are in the public ministry warehouse located in Asunción. 100% of last year's piracy procedures were performed in the last quarter of the year, and something similar happens with the National Directorate of Customs, where 22 out of 28 procedures were performed in the last quarter, coinciding with the change of government and the appointment of new national directors. The District Attorney's Office reported that his units in Asunción performed in 2013 58 procedures of seizure of counterfeited goods and 12 procedures of destruction. It also reported that there are currently 46 investigations in course, 21 of which included DA indictment and 4 sentences in case of IP violation. The District Attorney Unit in Ciudad del Este reported that they have currently 140 cases under investigation, all of which received an indictment and 1 sentence. Interlocutory injunctions issued by the Supreme Court in criminal cases are brought before the Specialized Intellectual Property Court, highlighting the 34 alternative and 33 destruction of goods made under judicial review. Performing the summation of the products seized in Paraguay in 2013, its market value is estimated at approximately $180 million. In August 2013 was enacted the law number 4989 that creates the National Secretariat of Information Technology and Communication, SENATICS, under the executive branch. This act provides for the first time the general framework for the formulation of the public policy in this sector. The creation of SENATICS allows achievable plans and promoting good practice in the management of IPR. One of the purposes of this department is to monitor the public procurement system in all that relates to the incorporation of technology in public institutions. It must also advise in procurement of equipment, systems, and softwares. SENATICS has signed an agreement with the National Directorate of Public Procurement to standardize procurement of computer programs by public institutions. Finally, I wish to inform that on March 11th and 12th, we will resume the negotiation on the Memorandum of Understanding between Paraguay and the United States on IPR. On that occasion, the new National Director of Intellectual Property will be part of our delegation. Thank you very much.
Thank you. Obviously, we're very encouraged to hear about these positive developments, in particular the establishment of DNAPI, as well as President Cartes' recent public statements about Ciudad del Este and his administration's goal of transforming the city into a legitimate business hub. And also thank you for your interest in renewing the discussions on the renewal of the bilateral MOU. We very much look forward to that process beginning in March. I believe we have 2 minutes, 1 minute. So I think we have time for one question. We have some additional questions, but we'll provide those to you in writing after the hearing. So one question.
In last year's special 301 identification, we noted the issue of protection against unfair commercial use of test data for agricultural chemicals and pharmaceuticals. I was just wondering if you had any update on that issue that you could provide with us.
Can you repeat the question because the
Oh, sorry. Last year, we identified the issue of unfair commercial use, protection from unfair commercial use for agricultural chemical data and pharmaceutical test data, and we were wondering if you had any update on that issue for us.
that is related to the years that products are protected or the use the
Protection for the data for a certain period of time.
yes. We don't have much information about that, but with the new administration, with the new National Directorate of Intellectual Property, we are revising all the measures in this area, and some of the improvements are in this report, and some other we can give you later. So this specific issue I take note and I give you.
Thank you.
Sorry.
That's great. Okay. Thank you so much for joining us today, and we'll follow up after the hearing. Thank you. Thank you. And now I'd like to invite the government of the Philippines to the table, please.